Hello, everybody. Welcome to the Debt Hotline. Thank you so much for tuning in. Thanks for listening. Thanks for joining. We're really excited for tonight's topic. We're going to be talking a lot about bankruptcy tonight.
Woo.
We have a wonderful special guest. Tonight's topic, more specifically, is how does bankruptcy affect your credit? And we're going to be having a live Q&A with Ben Jackson. I wanted to introduce Ben real quick before we jump into things. So Ben is the co-founder of Upsolve, which is the biggest and most impactful bankruptcy nonprofit in the US. And it's helped, I don't even know what the number is now. I think the number I have is probably outdated, but I have on here more than 13,000 people find freedom from more than $700 million of debt. Ben, is that right?
18,000. We're over 18,000 and we're going to cross $1 billion in the next month. So
amazing. So that number is outdated. I need to go and fix that. But so
no worries. Always fun to have a chance to one up you. So I'm into it.
I love it. So Upsolve's helped more than 18,000 people file bankruptcy and protect more than nearly $1 billion, you said, in debt?
Yep. Closing on $1 billion. Yep.
Incredible. So a little more about Ben. He has a law degree from Chicago Kent College of Law. He has personal experience filing Chapter 7 bankruptcy and freeing himself from the burden of debt. And so he is definitely an expert in this topic of bankruptcy. And we're super excited to have him on tonight and talk a little bit about how bankruptcy affects your credit. Ben, do you want to fill in any gaps? Did I miss anything?
Sure. Well, no, you know me, I like to talk, so I'll keep it brief. But yeah, not only have I filed bankruptcy, but I attribute the fact that I today own a house and can provide for my family, my 1-year-old son that just turned 1, all to bankruptcy. Like if it was not for finding and filing bankruptcy, I would still be stuck where I was back in 2015, 2016, driving for Uber and Lyft, trying desperately to pay down $60,000 in credit card debt. Wasn't going to happen. Like I was just getting myself deeper and deeper. And the fact that I was able to break out, get on my feet, go to law school, and build the life that I have today, I owe that entirely to bankruptcy. So I am a very big fan, really excited to help people understand how it impacts their credit, how they can start over after bankruptcy, just like I did.
Okay, so I'm not trying to age you, Ben, but how old were you when you filed bankruptcy?
Oh man, that's a good, how does time even work? This would have been, I was 29 when I filed bankruptcy.
You were 29, and here you are, you said about 10 years later, and you own a home, you have a family, and life has totally turned itself around, it sounds like.
Yeah, I mean, I won't pull you deep into the weeds of my finances unless anybody wants to, but yeah, I'm in a point today financially that I never thought that I could be in, but that I always knew I could be in if somebody just gave me a shot, because I was working super, super hard, right? Like I was grinding 60, 80 hours a week for Uber and Lyft. I was working for Instacart. I was doing every little thing that I could do, pulling the Dave Ramsey lifestyle, right? Saying like, if you just work harder, if you just deprive yourself, you'll eventually dig out. Didn't work. Added bankruptcy to that mix. Fast forward a few years and I'm in an awesome place financially. So you can get there too.
I love that. It's a super hopeful story. And, I wanted to dig in a little bit deeper. Obviously, you don't have to get into the details of your finances, like you said. But Ben, can you tell us a little bit about how does bankruptcy actually affect your credit score? And in your particular experience, what kind of effect did it have on your score?
Yeah. So for most Upsolve users, they don't really see much impact on their credit score at all, because usually by the time you're to the point of filing debt, which the average Upsolve user has about $36,000 in debt, they're behind on a lot of that. Usually by the time you reach that point, your credit's already kind of in the toilet, right? Like most people we see, they're down in like the mid to low 500s at that point. So filing in that world really only ends up having a positive effect. And in many instances, you see that immediately. You file, that bad debt goes off your report, and then it's all just sort of like age of credit and things like that. And you actually will see a boost pretty quickly after that. For me, I was kind of a weird case where, because I had been trying so hard to stay current on my debt and succeeding, my credit really hadn't taken much of a hit. Now, I wasn't really making an impact on that debt. Like it was just getting bigger and bigger, but I wasn't late on payments. So for me, I took not a huge hit, but I think I went from about a 710 score initially down to like 650 or so. But I was within about a year and a half back up in the 700 range again by doing things like getting secured credit cards, doing rent reporting, which is something a lot of people don't realize you can report your rent on your credit score, and using programs like Kickoff, if you've heard of that, to do some things to kind of like deal with bad lines that were showing up, dispute some things, and really just get back on my feet quickly with that credit score. And that's the case with most Upsolve users. Like usually you file, it has no negative impact. And then if you do these credit boosting things that we talk about, within a year or two, you're in the like low to mid 600s and then back up into the 700s within like 2 to 3 years post filing.
So it sounds like most people who may get to the point of wanting to file bankruptcy may have already seen an impact on their credit score just due to late payments, struggling to manage that debt. And so even filing usually won't have a huge hit on the credit score itself. But it sounds to me, based on your answer, that after a couple of years, if you can stay current with all of your accounts, that you can see your score improve significantly, and you can even get back up to the 700s if you play your cards right. Is that right?
Absolutely. Yeah. People are very often like, I was very worried what this is going to do to my credit, right? Like, am I never going to be able to buy a house? Am I never going to be able to buy a car again? Am I not going to be able to get student loans to go to school eventually? And I was in the situation where you have to worry most about that, like where I had a good credit score and it took a hit from filing bankruptcy. And I was able to go to school, get student loans. I was able to get a mortgage on the house that I have at a standard rate within a few years. So if I didn't have to worry, most people who are already suffering because their debt is impacting their credit really don't have to worry about those impacts.
That's amazing. And it's super hopeful because I think, I don't know, in my experience, even that sometimes there's a lot of taboo stigma surrounding the topic of bankruptcy. Like, if you hear someone's filed bankruptcy, you might just think they don't know how to manage their money or whatever. I don't know if I personally feel that way, but I know that in general, like there can be a stigma against just the whole idea of it. And it's really nice to know that it's not the end. It doesn't mean that you aren't good at finances. It doesn't mean that you're going to have a terrible credit score for the rest of your life.
Yeah.
It just means that it's giving you a chance to start over. And Ben, I love your story. I love to hear that, 10 years later, you're in a very stable situation with a home and a family, and, you're able to turn that financial debt and burden right around. So,
yeah. When I'm slow, like I had a user early on, her name was Keisha, who called us back like a year and a half after filing. And she was like, my credit score is already back up in the 700s. Like I just got a car loan and I'm working on a home loan. So like it can happen much faster even than it did for me. And it does every single day for our users.
Amazing. Can you tell us a little bit about your personal experience filing bankruptcy? And then can you tell us about, how, if you had at the time had a tool like Upsolve, how things might have been a little different for you?
Oof, boy. Yeah. So my personal experience was a mess. And this is partly to do with who I am and partly to do with how challenging it can be to figure out what forms you need to do and in what order and on what timeline if you do this entirely on your own without guidance. So I decided let's see, this would have been probably like June of 2016, I want to say, that I needed to do something, that bankruptcy seemed like the only option for me and I needed to pursue it. So I started talking to attorneys, right? Because bankruptcy is a legal thing. I think attorneys, first of all, when you do any legal thing. So I started talking to attorneys that I found on LegalZoom saying like, hey, what do I do? And didn't realize what I was getting myself into. The world of bankruptcy attorneys is a very mixed bag. There are some awesome ones and there are some less so. And there are also lots of different types of bankruptcy and not all of them are good for everybody. So I found a bankruptcy attorney that really only did Chapter 13 bankruptcies. Quick primer on the difference. Chapter 13 is a repayment plan where the court sets up a plan with your creditors and says, okay, Ben can't pay $60,000, but we're going to get him to pay $30,000, let's say, over the next 5 to 10 years. And if you can, make good on this payment plan, the debt goes away at that level. That type of bankruptcy can work for some people. It definitely wouldn't have worked for me at the debt level that I had. Chapter 7 is the type of bankruptcy where your debt is just wiped out. We call it the fresh start bankruptcy. Any unsecured debt like credit cards, personal loans that doesn't have a car or home or personal property attached to it will get wiped out if your Chapter 7 is approved. That is what I ultimately needed and ultimately found. But the first attorney that I found didn't do that type of bankruptcy. They only did 13s. And I was like to the point of like signing on a retainer agreement with them to pay them $3,000 to basically never get out of debt because I wouldn't have been able to pay off that plan. When I just happened upon in description of Chapter 7 somewhere on the internet. I don't even know where I found it. It's one of those, who knows where anything comes from the internet? Like it finds you. I found this description of Chapter 7 and I was like, oh, this seems like a way better option for me. I should pursue this. So that evening or next morning or something like that, I started trying to get together the forms. Now, I had lived in Chicago for a long time. I moved down to Texas from Chicago. I had lived and earned money in a couple of different states doing rideshare work on the way to Texas. And I sat down and I looked at these forms and they have these long descriptions about what is residence and jurisdiction, what are exemptions, what can you use, what can you not use. Very long story, very short. 4 months later, I had stacks of paper from every state that I had ever been in my living room, like every tax return for every job ever that I'd ever worked all over my house. It was a fire hazard. And I was like, what the hell am I doing? Finally, by some miracle, ended up going to court with the wrong packet, gave it to the clerk, and they said, hey, honey, sweetie child, like, let's do this differently than this. Got me the right forms, helped point me in the right direction, and I was able to file that bankruptcy. And 3 months later, walk out the door of the court with the fresh start, a piece of paper that said my debt was gone. So I tell you this story because I consider myself now somewhat of an expert in bankruptcy. There's definitely people that know more than me, but I've helped a lot of people with it. And I could not figure out what I was doing on my own. And not only did that not matter, but it didn't matter in the ways that I thought it most likely to matter, right? Like I thought I was going to go to court and they were going to be like, how dare you come in here with the wrong forms? Like, how dare you do this, sentenced to debtor's prison forever? And I thought like court clerks and things like that were going to just give me the side eye and like not be helpful. And it was amazing how helpful the court clerks were in helping me walk through that scary process, how helpful the judges were ultimately, because I did have to go stand in front of a judge to do what's called a reaffirmation to keep my car, how helpful the trustees were. It is a process that really is designed to help you. And so if there's any one thing that I would give you from my story, it's that it's very complicated. Get help if you can, and Upsolve can be that help now. And it's not nearly as scary, and you're not nearly as alone as you think you are when you go into it in the first place.
So it sounds like you almost filed Chapter 13 bankruptcy.
Almost did, yep.
And luckily you didn't. You came across Chapter 7 information online. Then you filled out the wrong packet, took it to the court, and then it sounds like you got some help.
They helped me, finally was able, yeah.
People.
Yep.
But
they're
that's
more helpful than you think, yeah.
But that's not always the case, right? Like, yep. I think usually people want to just lend a helping hand where they can, but I think court professionals are often busy, and so they can't always like walk you through step by step. So that's why I think tools like Upsolve are so important. Can you tell us a little briefly how Upsolve works, and then we'll jump into some questions from
the short version is I took 6 months to put together the wrong forms, and my house was full of paper at the risk of almost burning down, right? Like it was a fire hazard. And I started Upsolve because it doesn't need to be that way. You can go through our tool. It's a TurboStack style workflow that asks you the questions to figure out what forms you need, and then asks you the questions to fill out those forms for you, and then gives you a packet in hand with clear filing instructions, with forms that are ready to go, that have a success rate that's as good as and often better than most attorneys filing bankruptcy forms, that you can take in with confidence. Like we hear all the time from court clerks and trustees, like, who put this packet together for you? Like, this is so good. And the reason for that is because we've worked now with over 18,000 people. We understand what it takes to get a packet approved by what's called a pro se filer, which means you do it on your own without a lawyer. And we take that 6-month process that I went through and shrink that down to a couple hours that you spend on a really easy, totally free system to get forms that you can file successfully.
Beautiful. And I think the key here is that it's free, right?
Yes, 100% free. I need to put Upsolve is free on this t-shirt. Yeah.
I think that's the coolest part. It's like almost seems too good to be true.
Yeah.
But I know that Upsolve has seen a lot of growth as a nonprofit over the last year, like
Mhm.
within 2025, right? I think you guys, the amount of filings that people are doing through Upsolve has increased by, do you know what percentage?
Let me think. So we're on annual run rate right now for 8,000 filings, and we did 2,700 last year. So we, whatever that is, 3x, something along those lines. I can't math past like 5 p.m., but yeah.
Well, incredible. For anyone watching, listening, if you're considering bankruptcy, specifically Chapter 7, head on over to upsolve.org. And it could be a really great tool to help you at least get you
Yeah.
pointed in the right direction.
Yeah, if nothing else, like, the first step in this thing is like, is bankruptcy for me and can I file it, right? Because it isn't for everybody, not everybody can. And so the first thing we do is we have a really quick 2-minute screener that helps you figure that out. If it is for you, you can then continue on to our app workflow, get your forms at the end of it, or you can talk to a bankruptcy lawyer for free in our network, where we'll say, okay, this isn't for you. Maybe your case is a little bit more complicated. Maybe you just need some guidance. Here you go. And we have a network of attorneys around the country that'll help figure out what next steps would be and the best way to protect assets and things like that. And then you can work with them if you choose to.
Wonderful. Well, thank you for sharing your experience, Ben. Thanks for giving us a breakdown of how Upsolve works.
Of course.
Again, for anyone interested in exploring Chapter 7 bankruptcy as an option and wanting to do it for free without having to, find an attorney or go through the 6-month process and having a fire hazard in your house with all your paperwork, head on over to upsolve.org.
Don't be Ben. Be Ben. Be 2025 Ben, not 2016 Ben.
I love it. Okay, awesome. Well, we actually have some great questions that were submitted to the debt hotline
Sure.
before we started tonight. So I'm going to go ahead and read some questions. For anyone watching live, you can go ahead and submit your questions in the chat. I see we're getting some questions already. So we're going to kind of be popping back and forth between the live chat and then questions that were submitted beforehand.
Let's do it.
So Ben, our first question of the night is actually from Kristen in Florida. Kristen says, I owe approximately $70,000 and it's so much that I cannot keep up with all the payments. So close to the same amount you owed, Ben.
Yep, been there.
She says, my husband and I own a home together and I have a HELOC loan through my banking institution. If I were to file bankruptcy minus the HELOC, would that affect my husband's credit?
Good question. Would it affect your husband's credit? So it would only affect your husband's credit if you filed jointly. So what you can do is you can do a single filing by yourself on just your debt. And as long as you've properly kind of like segregated out what these assets are such that they wouldn't be what's called like liquidatable or dischargeable in the bankruptcy, such that your home equity isn't at risk, you would be able to file and it wouldn't affect him. Now, where you do own a home, that's typically something where I would say you probably want to work with a lawyer, because what does and doesn't count as equity, meaning your portion of the home that you own, is a little bit complicated, especially if you have a home equity line on top of that. So I would definitely say go over to our tool, upsolve.org, run through the screener. It's going to tell you relatively quickly, like, hey, Upsolve can't help you, but it'll get you connected to an attorney in your area who can. And if not that, send us an email and I'll connect you with a debt management plan provider that we know and trust that can help you work out something where you wouldn't even risk the assets in the bankruptcy. You would just be able to potentially negotiate down a consolidated lower interest rate on those payments. But I feel your pain on that. That really stinks. It's a hard spot to be in, but bankruptcy still could be an option for you in a way that wouldn't hurt your husband's credit.
Great answer. I don't even have anything to add to that. That was wonderful. Our next question is from Jay in Colorado. Jay says, I've been paying a debt off with a low amount since 2015.
Mm-hmm.
It has since been removed from my credit scores. There was an attempt to sue me in 2022, but I signed a stipulation to put the court on hold. I did not fully understand what I was signing, and they ignored my questions. I signed anyway due to the court date arriving soon. Now, 3 years later, I look at the balance, and it's over $5,000 more than before because of 8% interest. I was told by the collector that there was no interest, and I have not had any interest from when it was charged off in 2015 through 2022 when the law firm Rausch Sturm started the suit. What effect will it have if I do bankruptcy now?
What effect will it have if I do bankruptcy now? So there's a lot in that. I think the first 3/4 to 4/5 of this question is a debt lawsuit question, better answered by Hannah and Solo. So let me answer the last part, then Hannah, you can talk a little bit about if there's any other things to consider or try to deal with this. So can you remind me again in that question, what was the current status of that debt? What's the total amount or the amount of the difference? 5,000?
Yeah, so Jay says that he got sued in 2022 by Rausch Sturm, and he signed a stipulated judgment at the time, which means I think he agreed to settle the debt
Yep.
and get on a payment plan. But he didn't understand what he was signing at the time.
Sure.
And so now he didn't understand that there was going to be interest
Sure.
accruing on the debt. And so
Yeah.
now he owes $5,000 more than he originally owed.
Okay, got it.
And he's
So-
wondering if he files bankruptcy now, how that will affect this whole stipulated judgment.
Yeah. So with the caveat, I'm not a lawyer. This is not legal advice. I'll say that when you file bankruptcy, any non-secured dischargeable debt, which means, and so just to break those words out, non-secured means you don't have personal property that you promised to give up if you defaulted on the debt. So it's usually a car loan or a home loan. So if you have unsecured debt, so things like credit cards, personal loans, etc., many of the times judgments actually count as unsecured debts in those instances that are dischargeable, which means they're legally allowed to be forgiven in bankruptcy. So that would exclude things like late child support payments. What you're talking about sounds like a dischargeable debt. It sounds like it's very likely unsecured. And so it sounds like it would be dischargeable in a bankruptcy proceeding. And our tool can help you figure that out as you work through the workflow. It'll let you know, like, is that debt specifically dischargeable or not dischargeable? And then we have paralegals on staff that can kind of help you figure out what the best move going forward is if you are in fact eligible to discharge it through our tool. Now, if it's not dischargeable, so if it's determined that it's something that either legally is not allowed to be discharged, or it is in fact secured by personal property in some way, such that you would lose that property if you filed bankruptcy, in that world, you could potentially discharge the rest of your debt through bankruptcy, and then that 5,000 plus whatever the amount of the judgment was would potentially survive the bankruptcy, which is potentially feasible, right? Like if you're spending $10,000 a month on your debt and then 3/4 of your debt goes away, you now have a bunch more money that you can use to pay off that judgment and the interest on top of that. Now, as far as the questions go about the debt lawsuit or things to do when you are erroneously being collected on, Hannah, that's your department.
Yeah, so I would say, if the lawsuit was filed for a debt that you don't actually owe, or if, you dispute the amount that you're being sued for, like, it's always really important to make sure you file a response to the lawsuit. Like, that's the number one thing that you do when you get sued for a debt: file an answer. Even just the act of filing an answer can give you leverage to negotiate. Even if you do owe the full amount that they claim that you owe, it can give you leverage to negotiate and settle for less, and just resolve the case without having to go through the whole court process. So filing the answer is definitely the number one thing that you want to do. And we can help you do that at Solo. So we have a tool called Solo Suit. It's our debt answer tool. It's similar to Upsolve in that it's kind of like TurboTax. You go and you respond to a series of questions about your case, and then our software helps you create an automatic response to the lawsuit. But then we take it a step further and we also help you file it. So we file the answer for you with the courts, and we also serve the opposing attorney for you. So I think that, again, number one thing to do always if you've been sued is be sure to file an answer. Like, you don't want to miss your deadline to respond, because if you do, an automatic judgment could be put in place, which would include oftentimes interest. So you end up paying way more than you were originally sued for. In this particular circumstance with Jay, I'm sorry that you signed something. At this stage, it would probably be difficult to reverse that because you did agree to it. So another thing that's super duper important to do when you're, negotiating a settlement is read the fine print. Be sure that you understand what agreement you're getting yourself into, what interest is involved, all of those things. We have a tool at Solo called Solo Settle that can help you negotiate and settle your debts outside of court, protect your legal rights, settle for less, or get like on a payment plan to kind of help you get back on track. And we also help with the documentation of that settlement agreement. So that's another tool that you can use if you're in the process of negotiating and try to settle the debt. But always read fine print on the agreement before you enter into it.
Right.
I'm sure I would say to Jay, I'm sure there are maybe ways that you could, I would probably recommend talking to an attorney and seeing if there are ways to reverse the judgment or at least to alter it. You could also contact Roush Sturm directly on your own and see if there are ways to settle the amount that you're already entered into. They're not always going to, stick with the original agreement. So there is a chance that you could still negotiate and change things up, but it might be more difficult at this stage since you did sign the agreement. Okay, we've got lots more questions coming in. We've got one from Dennis. So Dennis says, I'm trying to find out if an American living out of the country can file for Chapter 7 bankruptcy in Florida.
Interesting. So where you can file is based on where you live, like what is considered to be your legal residence, and what are called exemptions, which are the things that you can choose to cover your property so that you don't lose all of it if and when you file bankruptcy, are based on very complex logic that our tool can help you figure out, but it's to do with like where you've been for the majority of the last year or so. So if you're living out of the country, you generally can't file from out of the country. You would need to be back in the United States. There are some jurisdictions that will allow you to do like virtual 341 meetings with a trustee, but you would still need some way to actually file. So you'd need your jurisdiction to both take mail-in filings, which not all of them do, and do remote 341 trustee meetings if you were to do this from abroad. So it is doable. It's just generally very hard unless you live in a jurisdiction or would be filing in a jurisdiction that allows all those things. So I would encourage you to say, okay, what jurisdiction would I file in based on my Florida address? Look at the court's website, see if they allow for mail-in filing or e-filing of some type for consumers, not just for lawyers, and then check to see how they do their 341 meetings, if it's remote or not. If they require in-person 341 meetings or require in-person filing, you're going to actually have to go back to Florida to do this. But living out of the United States for any period of time wouldn't preclude you in most instances from being able to file as long as you do still have a legal residence in the US. Now, if you don't have a legal residence in the US, I actually don't know the answer to your question. I would suggest talking to a lawyer.
So it all depends on residency. That's good to know. Dennis had a follow-up question. He says, I have a zombie debt collector resurrecting a $450,000 judgment from 10 years ago.
Whoa.
They began seizing all of my assets.
Yikes.
And Chapter 7 be filed to stop them from seizing the rest of my retirement assets. So it sounds like there's already a judgment in place for $450,000. You're seizing his assets. Would Chapter 7 stop the rest of his assets from being seized?
So it should stop all debt collection activity against you. It kind of depends on how those asset seizures are being executed. So usually what happens when you file bankruptcy is something called the automatic stay goes into effect. And what that is a ruling that says, okay, while we're figuring this thing out, while we're helping them figure out what debt can and can't be paid off, what the assets they have, nobody can collect against them. And it kind of like organizes the whole thing and puts it under the jurisdiction of someone called a trustee that then helps facilitate that process of figuring out your debt, figuring out your assets, figuring out if there's anything to be paid off, etc. So for most debt collection activities, they are required to stop, and 99% of the time they do stop post-filing bankruptcy, as long as the collector has been alerted that you filed, which we help you do during the filing process. So the judgment that you saw on there, that $450,000 judgment, what was it for? Did he say what it was for? Foreclosed commercial mortgage. Okay, yeah. So typically a commercial mortgage would be a dischargeable debt, like the differential owed on that if the property was seized, paid off, and you have the remainder left. They usually would be dischargeable through bankruptcy. So that should be able to go away in that bankruptcy proceeding. And retirement assets are also typically exempt from being seized by a trustee to pay off your debtors during a bankruptcy. So bankruptcy could potentially be a good way for you to get out from under that massive debt burden. That must be really stressful.
Okay, awesome. Let's got a couple other questions here. This one says, how come you guys don't work in North Carolina? Is that directed to Upsolve?
It is. Yeah, boy, would I like to. So there is a fun little thing for anyone in here that has been to law school or thinking about going to law school. Let's make this go away. There's a fun little thing in most states called the unauthorized practice of law regulation. And what this is, they are not really laws. They're sort of just like practices that are enforced by bar associations that determine who can and can't practice law, and they define what is considered to be the practice of law. So let's say that I stand up for you in court and I say, I'm your lawyer, right? Like that's very obviously me practicing law or putting myself forward as an attorney, and therefore I should be, regulated as an attorney. There are other things that are a little bit more difficult, like, is it the practice of law if I take publicly available information about how to file bankruptcy and I translate that into a language that you can understand because it's not written by lawyers, it's written by humans. I put that in front of you and you use those instructions to file bankruptcy. There are some states that say yes. There are most states that say no. North Carolina is one of the states that's a little bit stricter about this, and we don't think there's a way for us to operate safely to help people in North Carolina without getting shut down. And the ways that we have found to work there require us to not be helpful enough for it to be worth your time in those states. So it's a tricky thing where we would love to help you there, but just can't due to the current regulatory frameworks there. So if you are in North Carolina, you can still start our tool and we can help you find a local attorney that can work with you there.
Yeah, and I think one thing I love about Upsolve, since it's a nonprofit, Upsolve's number one concern is like impact and helping people. So, I don't think that revenue is always top of mind for Upsolve. Like you guys are trying to help people. And so I love your answer about why you're not currently operating in North Carolina. Like it would be maybe detrimental to users in North Carolina to offer those services. And so instead you can help people get started and then help them get connected with the right resources that they need.
Yep.
Love that. Okay, next question comes from Arizona Hardscaper. Says, what are reasons a Chapter 7 filing can be denied by the courts?
That's a great question. So the most common thing we see isn't a denial. It's sort of like we're closing this case because you didn't do the things you needed to do to get it finished. So you were getting notices about maybe additional documentation needed, or you have a 341 meeting with the trustee on this date that you didn't respond to. And so your case just didn't proceed. The only time we ever really see denials is if someone like blatantly lied on their forms, like was trying to hide significant assets that they were worried about the trustee taking to repay their creditors. I very rarely actually see denials. I don't even know. I can count on like two hands the number of denials we've even seen the forms that we filed. Most of the time it's, I took this and I didn't do what I needed to do to ultimately get a discharge through those proceedings. If you need it, like to go from my earlier example, like of my own story, the courts want you to be able to file bankruptcy, right? Like this is a thing that the US is sort of like miraculously and uniquely included as part of our law to say that we believe that sometimes debt just gets away from you. And we believe that that shouldn't keep people from being able to participate in the economy. And so we're going to make this and enshrine it in our law almost as a right. And judges, clerks, trustees, really, for the most part, all have that perspective. And so they're not here to deny your bankruptcy. Now, if you're trying to manipulate the law, if you're very obviously like racking up an enormous amount of debt and trying to file bankruptcy so you can get rid of it and trying to exploit the system, then you might get your case denied. But 99.9% of the time, people that are filing bankruptcy really need it, aren't doing it for fun, and won't get denied unless they do something totally crazy in the proceedings.
Got it. So it sounds like for most Chapter 7 cases, the court will be pretty friendly and work with you.
Yep.
Gotcha. Okay. Next question comes from Carlos in New York. Says, at age 22, I have a $7,000 in unpaid tuition debt, which I have been summoned for, and $5,000 in student loans.
Mm-hmm.
And then a follow-up question. Let's see. Says, would filing for bankruptcy be a good option due to the time I have to rebuild and invest the money that would be used to repay debt to accrue interest? Or is it better to pay for the debt due to credit damage?
I like your question. So you're thinking about this the right way, Carlos. Money that you don't pay towards other debt can be used to pay off debts that you can't discharge in bankruptcy. So let's say your student loans, that tuition, the $7,000 and $2,000, I think it was, those are not going to be dischargeable through bankruptcy 99% of the time. There are some rare cases where you can. Our tool can help you figure that out. But for most people, that type of student loan is not going to be dischargeable. Now, that's okay, right? Because maybe you have other credit card debt, personal loans, etc. That's still money coming out of your pocket every single month to pay off those debts that you can't use to pay off your tuition debts. And as soon as those debts are gone through a process like bankruptcy or a debt management plan, or, to your point, just paying off the debt yourself, then you're going to have more money to pay off those debts that you can't discharge in a bankruptcy, like student loans. So I like the way you're thinking about it. Keep trying to be creative. I guarantee that creativity is going to get you out of debt in the near future. So keep at it.
Love it. Okay, next question is from Jordan in Indiana. It says, I'm in a situation where I lost to a creditor for a substantial amount. I have a discovery date soon, but I want to settle before. I don't have a lawyer and I don't know what to do.
If only we had a company that helped with debt lawsuits and settlements.
Yes, so I think this is a really good opportunity to put a plug in for Solo. So we actually have a tool called Solo Settle. It's an online platform that helps you get connected with creditors and collectors and negotiate your debts outside of the court process to settle your debt for less. So, you can do this before your discovery date, before your court date. And it's just a way to kind of help you make sure that your rights are protected when you're negotiating, make sure that you get all of the negotiations documented. And it also, we guarantee that you'll be able to save money on the settlement that you negotiate. So in some cases, it might be in your best interest to settle for less. In other cases, it might be best to just get set up on a payment plan where you ask them to knock out the interest that you would accrue if a judgment were to be entered into the case. Because in most cases, if you lose and there's a judgment, you're going to end up paying significantly more, like our friend from earlier had to do. So, in some situations, it might actually be in your best interest to just pay off the amount that you owe over time. And our platform can also help you negotiate that kind of payment agreement and get those payments set up and automated to where they're just coming out every month and sent straight to the collector or creditor that you're working with. So again, Jordan, if you're listening, go head on over to solosuit.com and you can get started with our tool called Solo Settle. And for anyone watching live, I'm going to go ahead and share a link here in the chat for you to, just jump straight to the website and get started on that.
Gabriel, I feel like this last piece of advice you threw in the chat is like a copy paste that I see in like almost every financial conversation of all time. It's like it follows me around the internet.
Is that
being helpful in there? The irrevocable trust idea and the LLC to build business credit. It's so funny to see that so frequently in these things. Was there another question you had that you wanted to answer first, Hannah, or can I take a stab at that last one about the irrevocable trust?
Yeah. So you're talking about the one from Gabriel?
Yeah.
Okay. Yeah. Let's go ahead and read this one. So from Gabriel, it says, is having an irrevocable trust that is granted to me safe for me while filing Chapter 7?
Okay. Irrevocable, irrevocable. We got a tomato debate going on here. So an irrevocable trust can be safe in a Chapter 7 bankruptcy, but it kind of depends on how it's set up. So if you are entitled to specific withdrawal amounts or disbursements from that trust currently, there's a chance that the trustee would consider that part of your bankruptcy estate and be able to seize those specifically to pay off creditors in your bankruptcy proceeding. Also, if this is something that you just did like recently in the near past, they'll do what's called like a clawback and say, hey, it looks like this was, just set up. We actually think that this is part of like the current state of affairs that led to this debt. And so therefore, we think we should be able to undo this irrevocable trust and get access to all the assets inside of it. But if it's something that was like very clearly set up, a decent while in the past, it's something that's existed there for your future benefit, and you are not currently entitled to any assets equity from that, very often in a Chapter 7 filing, that would be safe. Again, our tool can help you figure out if it's protected by the exemptions in your state. And if this is something where there's some risk to that, we can help you get connected with an attorney that would help you be able to better apply and protect that trust in filing. But by default, it's not necessarily at risk in the bankruptcy.
So just to clarify, the irrevocable trust, I'm not sure myself how to pronounce it.
No one knows.
It would be protected in Chapter 7.
It could be. It very most likely would be. Now, the one caveat with this is those are often used, not often, but like they can be used fraudulently. I think I saw somebody a second ago. Where was this? Someone said in here, put those assets in an irrevocable trust and then file bankruptcy. So that might work, but when you do something like that very close to your bankruptcy, especially if you currently have a lot of debt and have been struggling at the point at which you do that, it's going to look fairly shady to the trustee during the bankruptcy proceedings. And there's a chance that they would be able to get that undone and get access to those assets. The bottom line is, don't try to hide assets when you're filing bankruptcy. Like, the courts are not going to take everything. A lot of what you have is protected by exemptions. And if you really need that bankruptcy, it might be worth losing some of those things in service of getting out of debt and getting back on your feet.
Awesome. Great answer. I think we've got time for maybe 2 more questions. We've got a couple shorty ones, so I wanted to read those off, and I think they'll be pretty straightforward answers. So the first one is from Ralph in California. Ralph says, how does the amount of cash in a checking account impact bankruptcy court?
Yeah, great question. So federally and in, I think, every state, there are protections for a certain amount of cash that you have. There's also usually what's called a wild card exemption. So let's say all of your other property is covered by other exemptions, and I should explain what these are. So in law, there are rules about specific types of property that the courts say you can't take this to sell it in a bankruptcy. So there's an allotment for clothes up to a certain amount. There's an allotment for knickknacks that you have around the house, for technology, the things that you need to live your life. And for most people, those exemptions, or those rules that cover those things, cover all of their property. Usually you don't end up in positions where the court will take and sell some of your property until you have significantly valuable property. Like the random number that comes to head as a cutoff is like, if you have stuff worth more than $10,000, that's where you start to be like at some level of risk. But for most people that end up filing, none of their assets are at risk. Now, cash is tricky, but if you had enough cash for it to matter, you probably wouldn't be considering bankruptcy.
Yeah, that's a good point. Yeah, hopefully you'd be using that to kind of, figure out the debt situation. Okay, awesome. Well, last question is from Lexi. Lexi in Texas says, would you recommend bankruptcy to someone in their mid-20s?
Would I recommend it to someone in their mid-20s? Well, I was pretty close to my mid-20s when I filed. And what I would say is, I'm going to give you guys the short version of my financial lecture. Time is money, and money is time in finance. Like, the longer you can save money and invest money and have your interest earn interest through compounding, the more money and the more security you're going to have in the future. It's insane. Like, you can go look at some of these like federal compound interest calculators. Saving like $100 a month from your 20s until you retire equals like literally like millions of dollars on retirement. And the less time you have, the less likely that is to happen, because most compounding actually happens in the last few years, which means what you do now matters the most. So the sooner you can get out of debt and start saving and investing in yourself and not paying that interest to credit card companies, but paying it to yourself, the better. It also gives you a longer period of time to recover any credit damage between now and when you might be in your home buying years. So if you have a significant amount of debt, if you are really struggling to pay it off, if you don't see a future for yourself that you're happy with in an amount of time that you're comfortable with, I would say filing in your 20s can be a great option, and it's going to put you in a position to be able to start saving and investing much sooner than otherwise.
Yeah, so I think this question is just so circumstantial, right?
Mm-hmm.
But I think the biggest takeaway I'm getting from all of this is like bankruptcy is not the end of the road. It's not gonna ruin your credit finances for the rest of your life. If anything, it's gonna help you start over, get back on track, get back on your feet, and then eventually prosper.
Mm-hmm.
So at least that's what it sounds like has happened for you, Ben. And I love that.
Yep.
Awesome. Well, I think we'll go ahead and wrap up. Again, for anyone listening, if you are being sued for debt, you can use Solo to respond to the debt lawsuit and also settle the debt and negotiate and protect your rights and avoid going to court altogether. So head on over to solosuit.com to get the process started there. If you're considering Chapter 7 bankruptcy, head over to upsolve.org and you can file Chapter 7 on your own for free.
Upsolve, it's free. I need to get the logo.
That's your new motto, right?
New slogan.
Yeah, but super wonderful tool. And I know many members of the Upsolve team personally and just think they're the bee's knees. So,
thanks,
so great people to thank you. Great people to work with though. And then lastly, I just wanted to also make a quick announcement before we wrap up and say that this month we are actually hosting a giveaway at Solo.
Ooh.
We are helping pay off someone's debt. So quick a little announcement. We're hosting the Dancing in September debt payoff giveaway, where we're going to pick one lucky winner to award $4,700 to help them pay off towards their debt. So $4,700 is the average amount that Solo users get sued for when they use our platform. And so we wanted to kind of give somebody an opportunity to pay off their debt lawsuit if they're being sued and just get back on track. So all you have to do is head over to solosuit.com/giveaway to enter. It's free. You just have to give us your information, your email address, and your phone number so we can contact you if you win. And then, yeah, we're also giving away mini prizes every week of $500 to weekly winners. Every Friday, we'll be announcing that in the month of September. So tomorrow, our first winner will be announced. But yeah, that just we just launched that this week. And want to give someone the opportunity to be a lucky winner and pay off $4,700 towards their debt. So head over again to solosuit.com/giveaway to enter for a chance to win. Ben, any last words on the topic of bankruptcy or anything?
Let's see. Well, I'll take it. I'll do a bonus question answer. Christina, the guy that was talking to you is wrong. That MCA could go away in bankruptcy. And if you are in the audience and you're really struggling financially and you really need a lifeline to get out of that, to get back onto your feet and to achieve your American dream, and you've thought about bankruptcy, but you think that's for poor people or lazy people or dumb people, you're wrong. It's for everyone who is struggling. It's something that banks and companies and even our president have used many, many times. It's a right enshrined in our law. And it's something that can very quickly and really powerfully help you start your life over. So don't listen to the hype. Listen to Ben and Hannah and check bankruptcy out at upsolve.org. It can be a great restart for many, many people.
Thank you so much, Ben, for joining. Thanks, everybody, again, for listening. This is the Debt Hotline. And just know that Solo and Upsolve, we're both here to help you with your debt issues and struggles. We want to help you find a resolution.
Yes.
So thanks so much for listening to